Kimberly, I want to start with you if I can, please. You've been a prosecutor, and when I heard this, my ears kind of perked up that I thought, wait, what? They're going to concede that this is privileged, and they're going to say we're not going to try to introduce this because we're acknowledging the privilege. Perhaps they're, a better prosecutor than I was, because I would have fought hard to get them in saying, look, this was recorded. They heard the announcement. They knew a third party was listening. They knew the government was listening. You can't say this was something like pillow talk in the bedroom. Tell me your reaction to the state's concession of that, please.
No, I absolutely agree. I was totally surprised that they conceded that. I literally expected them to argue to be able to get those calls in. Because just like you said, it's not like they were in a conference at their home having a conversation and their phones were tapped or somebody was, eavesdropping and listening. Like, it literally says, this is secure. It's being recorded. Anything that you say. So you already know it's being recorded, and this is a high-profile murder case, and they're going to listen to every call that's made. The judge would have to make the decision on this. There's no way I would have gave up those phone calls with his wife so easily.
I appreciate it, Judge. Brian Dunn, give me your take. If you were in that position, in the position of the state making the argument, would you have conceded that one?
Well, the whole thing is we have to understand what is the elephant in the room. And the elephant in the room is not necessarily the calls between the spouses. It's those other 1,500. And probably what they have in their, that they're holding in their vest are a lot of very incriminating calls that have gone from one defendant to the other defendant. So it may appear as though they're making a concession, but in reality, they may be doing a form of horse trading by saying, we just don't want to have a blanket rule, and we are going to take the high ground here and recognize the spousal privilege, probably because they're not that incriminating. But we're going to expect you to be fair to us when we're going to get all of these other calls in. And I think that probably is the story behind the story, as they say, Julia.
Sure. That's a really good point. Sometimes you lose a little battle in the short term, but you win the war in the end if you play your cards right. Appreciate that. Let's switch gears. So much to uncover here. I have just been beside myself watching this hearing go on and on. I want to talk to you both about this character evidence that these defense attorneys are trying to convince the court that it's proper to have it come in. We're talking about 10 prior bad acts, so to speak, with respect to the victim in this case is past conduct long before the incident that's in question. To me, I think this is a propensity problem, and they can't get around it, and there is no way the court should allow this to come in. I want to get your take on this. Do you see any legal exception for the judge allowing them to introduce any of these 10 acts? Judge Kimberly, I'll go to you first, please.
No, I don't. And I would be highly surprised if any of those remote acts that they had no prior knowledge of would be deemed relevant to help them with their claim of self-defense.
Right. And I'm so glad you mentioned that no prior knowledge of, because this is, I'm going to piggyback on that with your question, Brian. So when we talk about a self-defense case, we all know that sometimes if a defendant is putting forth a self-defense plea, then a victim's character can become an issue. As surprising as that seems, it can come in to show that if the defendant had a reasonable fear of this victim because of what he knew about him or her previously. But here, there's no evidence they knew a thing about Ahmaud Arbery. Brian, your reaction?
Well, there's so many things going on here, Julie, and it's really wonderful that you're exposing folks to what really happens in a trial, because all of the decisions that are going to be made in connection with these motions are going to directly decide what happens when this case gets before a jury. But the idea is there's always the arguments that are made, and then there's the real thing. The real thing is they want to prejudice Ahmaud Arbery, because if they can show that he's got mental health problems, if they can show that he's had prior spats with the law enforcement, if they can show that he has any kinds of unstable behavior, that's the kind of thing that's very hard to unring when the jury hears that. Because even though the judge may give a limiting instruction and say that you're not supposed to consider this for the purpose of determining how he acted, they always do. But one of the things that I'm hearing in the argument is the concept of expert witnesses. Now, expert witnesses can open the door because there's a basic concept of fairness, and that is, if you're going to try to say that you're a good person, then I get to try to say that you're a bad person. And experts can rely on anything. They can rely on things they haven't seen. So what I'm hearing is that if they have an expert talking about his state of mind, that actually could open the door, Julie.
Excellent analysis from you both. I can't wait to ask you more questions. You're going to kindly stay with us. I just am being told I have to take a commercial break. So we're going to step aside for that. When we come back, we're going to continue our live coverage of the motions hearing happening in Georgia over the killing of Ahmaud Arbery, and also turn our attention to another motions hearing, this one happening in Minneapolis, Minnesota today. Cameras were not permitted in the courtroom. No electronic devices were allowed in, but our crew was there. And so we're going to unpack everything that was discussed on the record for you next on Court TV Live. Don't go away.